All right, welcome back. You ever wonder what the real link is between some simple mistake and, a huge lawsuit? Well, it's not enough to just say someone was careless. Nope. You've got to prove that their screw-up actually caused the injury. And that, my friends, is what we're tackling today. We are diving deep into this legal puzzle called the chain of causation.
Okay, let's kick things off with a classic scenario. Picture this. An ER doctor makes a mistake. They're clearly negligent, and the patient dies. It seems like an open and shut case, right? The doctor's got to be liable. But as you've probably guessed, it's not that simple at all.
You see, the entire answer, the yes or the no, it all comes down to one single powerful legal concept: causation. Think of it like this. It's the rule that stops someone from being responsible for literally every bad thing that happens after they do something wrong. It's the essential bridge between "oops, I messed up" and the actual damage that follows. So how do courts actually build this bridge? Where do they even start? Well, the very first link in our chain is something called the but-for test. It's the first hurdle, the first gate that every single negligence claim has to get through. So what is this test? It's actually a pretty straightforward question. The court just asks, but for what the defendant did, would this bad thing have happened anyway? Now, if the answer is yes, if the harm was going to happen no matter what, bam, the chain of causation breaks right there. Case over. But if the answer is no, then hey, we've got our first link in the chain.
And this actually brings us right back to our ER doctor. This is based on a real famous case, Barnett versus Chelsea Hospital. So, a night watchman shows up, the doctor is negligent and sends him away, and the man dies. Sounds bad, right? But here's the crazy twist. Turns out, the man had severe arsenic poisoning. It was so advanced that the court found he would have died anyway, even with the best medical treatment in the world. So the court asked that all-important question, but for the doctor's negligence, would he have died? And the answer was yes, he would have. The claim failed. The chain was broken before it even started.
But, life is almost never that black and white. What happens when it's not just one person's fault? What if it's a whole mess of different things all contributing to the injury? This is where that simple but-for test starts to fall apart, and the law has to get a little more creative.
And the law's solution is this idea of material contribution. Basically, it means your screw-up doesn't have to be the only cause or even the biggest cause. As long as what you did contributed in a way that was, more than just trivial, that can be enough to link you to the harm.
A really powerful example of this is the famous asbestos case Fairchild. Here's the situation. A guy works for multiple different companies over the years, and he's exposed to asbestos at each one. He gets cancer, but science just can't prove which specific employer's asbestos fiber was the one that did it. See the problem? The but-for test would mean they all get away with it. So the court made a massive decision. They said, look, if each of you materially increased the risk that this guy would get sick, then you're all on the hook. It was a huge move to make sure there was justice, even when science couldn't give a definite answer.
Okay, so what about when things get even more complicated? Like what happens when you have one injury piled on top of another? Well, there are two really interesting cases that show how the law tries to untangle this. First, you've got Baker. A guy's leg gets hurt in a car crash. Then, later on, he gets shot in that exact same leg during a robbery. The court said the original driver is still liable for the leg injury. Why? Because you can't get off the hook just because some criminal came along later. Now compare that with a case called Jobling. This time, the second thing that happens is a natural disease. In that case, the court said the first defendant's liability ends where the disease begins. They called it one of the vicissitudes of life, basically the kind of bad luck that can happen to anyone.
And this leads us to a really dramatic idea in the law. Sometimes a totally new and unexpected event can just jump out of nowhere, ambush the chain of causation, and snap it clean in two. When that happens, the original person who messed up might be completely off the hook. There's a fancy Latin name for it, of course, novus actus interveniens. It just means a new act intervening. And honestly, the best way to think about it is like a huge plot twist in a movie. A twist so big, it completely changes the ending and becomes the real reason for what happened.
So, what kind of plot twist are we talking about here? It usually falls into one of three buckets. It could be something the injured person themselves does, something really reckless, or it could be a crazy, unreasonable act by some third party, or it could be a truly unforeseeable act of nature, and I mean like a freak meteor strike, not just a bad storm you could see coming.
Here's a perfect example of the first one, the claimant breaking their own chain.
In a case called McHugh, a guy's leg was made weaker because of someone else's negligence. Okay, fine. But later, knowing his leg was wobbly, he decides to go down a steep flight of stairs with no handrail while carrying a child. Of course, he falls and gets hurt even worse. The court basically said, look, what you did was so completely unreasonable that your action is the real cause of this new injury, not the original weak leg.
And a third party breaking the chain? Check out Knightley v. Johns. So, there's a car crash inside a tunnel. In the middle of all the chaos, a police inspector gives a truly terrible order. He tells another officer to drive his motorcycle against traffic back through the tunnel. The officer gets hit. The court found that the inspector's order was so grossly negligent, it was a novus actus. It broke the chain of causation, and the person who caused the first crash wasn't responsible for the motorcycle cop's injuries.
All right, so let's say you've got your factual link. You've made sure no new act came along and broke the chain. You're almost there. But there is one last gate you have to pass through. And this is really just a common sense check the law uses to stop things from getting completely out of hand. It's called remoteness.
And remoteness really boils down to this one question. Was the type of harm that happened something you could have reasonably seen coming as a result of the action? It's how the law weeds out all the bizarre one-in-a-million consequences. The test is simple. Would a normal, reasonable person have thought, yeah, that kind of thing might happen if I do this? The huge case that established this whole idea is called the Wagon Mound. A ship carelessly spills a bunch of oil into Sydney Harbor. Now, was it foreseeable that the oil would cause some pollution damage? Absolutely. But here's the thing. At the time, everyone believed it was basically impossible for that kind of oil to catch fire on water. So when a random spark from some welding work nearby actually did ignite the oil and burn down a whole wharf, the court said the fire damage was too remote. It just wasn't reasonably foreseeable.
But this is where the rule gets super interesting. You have to look at the case of Hughes versus Lord Advocate. So some workers leave lit paraffin lamps around an open manhole. Some kids are playing nearby. One of them knocks a lamp in and boom, a massive, totally unforeseeable explosion happens, and the kid gets badly burned. Now, was the giant explosion foreseeable? Heck no. But was the type of harm foreseeable? I mean, a kid getting burned from an unattended lamp? Oh yeah, absolutely. And that's the key takeaway here. As long as the kind of injury is foreseeable, it doesn't matter if the way it happens is totally wild and unexpected.
Okay, now we get to one of my absolute favorite legal rules, mostly because of its amazing name, the eggshell skull rule. It's this really important exception to that whole remoteness thing we just talked about. And the idea is incredibly simple. You have to take your victim as you find them. And the case of Smith versus Leachbrain shows this perfectly. A worker gets a small burn on his lip from a splash of molten metal. A burn like that? Totally foreseeable. But here's the tragedy. The man had a pre-existing cancerous condition that was just dormant. The burn triggered it, and the man died. The court said the defendant was liable for his death. Why? Because the initial injury, the burn, was foreseeable. And because of the eggshell skull rule, you're on the hook for all the consequences that follow, even if they're way more severe than you'd expect because of some hidden vulnerability. So let's wrap this all up in a quick checklist. To actually prove causation, you basically have to run through this whole gauntlet. First, you've got to establish that but-for link. Second, you have to show that the chain wasn't broken by some new intervening act. Third, you've got to get past the remoteness filter. Was the type of harm foreseeable? And finally, you have to ask, does the eggshell skull rule come into play here, making the defendant liable for the full extent of the harm?
When you step back and look at it, this whole complicated mess of rules, it's not really just about pointing fingers and assigning blame. It's the law trying its best to be fair. It's trying to balance being responsible for your actions with the fact that, life is just messy and unpredictable. It's this constant search for where to draw the line. So I'll leave you with the question to chew on. After hearing about all these cases, where do you think that line should be?